Indiana gives landlords broad freedom to set and raise rent, consistent with the state's overall landlord-friendly regulatory approach. The governing law is found in Indiana Code Title 32, Article 31, which covers landlord-tenant relations, and while it establishes important procedural requirements, it places no restrictions on the amount a landlord can charge for rent. Indiana does not have rent control or rent stabilization of any kind. There is no state statute that caps rent increases, limits the frequency of increases, or requires landlords to obtain government approval before raising rent. Indiana's political and regulatory environment strongly favors property rights and market-based pricing, and rent control has not gained meaningful legislative traction in the state. Indiana has enacted a preemption statute that prevents local governments from enacting rent control. Under Indiana Code Section 32, 31, 1, 20, a unit of local government cannot enact or enforce an ordinance, a resolution, a policy, or a rule that would have the effect of controlling the amount of rent that may be charged for leasing private residential or commercial property. This means Indianapolis, Fort Wayne, Evansville, South Bend, and every other Indiana municipality are legally barred from implementing rent caps. This preemption gives Indiana landlords certainty across the entire state. You don't need to research whether any individual city has additional rent restrictions because none of them can impose them. The framework is uniform statewide. For month-to-month tenancies, the landlord must provide advance written notice before a rent increase takes effect. Indiana requires at least 30 days written notice before changes to the terms of a monthly tenancy. So if rent is due on the 1st and you want the increase to take effect on May 1st, you need to deliver the notice by April 1st at the latest. The notice should be in writing and should clearly state the current rent, the new rent amount, and the effective date. Indiana doesn't prescribe a specific statutory form for rent increase notices, but a clear written notice delivered by a documented method, personal delivery, certified mail, or other verifiable means, is always recommended. For fixed-term leases, the rent is locked in for the duration of the lease term unless the lease includes a provision allowing midterm increases. Common midterm adjustment provisions include escalation clauses, provisions tied to property tax changes, and CPI-based formulas. Without such a provision, the landlord must wait until the lease expires to negotiate a new rent as part of a renewal or new lease. When a fixed-term lease approaches expiration, the landlord should communicate the proposed new rent well in advance. If the tenant agrees, a new lease or renewal is executed. If the tenant doesn't agree, the lease expires at its natural end. If the tenant stays and the landlord accepts rent, the tenancy converts to a month-to-month arrangement subject to the 30-day notice requirement. For week-to-week tenancies, the notice period for rent changes is 7 days, matching the one rental period standard. For year-to-year tenancies, Indiana requires 3 months' notice before changes take effect at the end of the annual term. This is important for landlords with annual leases that automatically renew. Missing the 3-month window means the lease renews at the existing rate for another full year. Now let's cover the restrictions that apply even without rent control. Rent increases cannot be retaliatory. Indiana has an anti-retaliation provision under Section 32, 31, 5, 7 that prohibits landlords from taking adverse action, including raising rent, in retaliation for a tenant exercising their legal rights. Protected activities include making a good faith complaint about habitability to a government agency, exercising any right under the landlord-tenant statute, and participating in a tenants organization. Indiana's anti-retaliation framework provides that if a landlord takes adverse action after a tenant's protected activity, the tenant can raise retaliation as a defense in any subsequent proceeding. Courts evaluate the timing, magnitude, and circumstances of the increase when assessing whether retaliation occurred. A significant rent increase shortly after a tenant files a code enforcement complaint, particularly when other comparable units aren't receiving similar increases, creates a strong inference of retaliatory intent. The consequences of a retaliatory rent increase include liability for actual damages, attorney's fees, and court costs. The finding can also undermine the landlord's position in any related legal proceedings. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and the Indiana Civil Rights Law, found in Indiana Code Title 22, Article 9.5, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, disability, or familial status. The Indiana Civil Rights Commission investigates fair housing complaints and can take enforcement action. Some Indiana cities have enacted local human rights ordinances that provide broader protections than state law. Indianapolis, Bloomington, and several other communities have enacted protections that include additional categories such as sexual orientation, gender identity, and in some cases, source of income. Landlords in these cities must comply with both state and local anti-discrimination requirements when implementing rent increases. Bloomington's source of income protection is particularly notable. It means that a landlord in Bloomington cannot raise rent specifically to push out a tenant who receives housing choice vouchers or other lawful sources of income. A rent increase that appears designed to target subsidy recipients while keeping rates stable for comparable non-subsidized tenants could result in a local discrimination complaint. From a practical standpoint, Indiana's rental market is diverse, with several distinct metropolitan areas and a wide range of conditions. Indianapolis, the state capital and by far the largest city, has the most active rental market in Indiana. The Indianapolis metro area's economy is driven by healthcare, including the IU Health System, Community Health Network, and numerous other providers. Logistics, advanced manufacturing, technology, financial services, and the convention and sports industry. Indianapolis has experienced steady population growth and economic diversification, and rents have increased consistently. The Indianapolis rental market varies significantly by neighborhood and submarket. Downtown, Mass Ave, Broad Ripple, and Fountain Square command premium rents driven by young professional demand and urban amenity access. The northern suburbs, Carmel, Fishers, Noblesville, and Westfield, attract families with excellent schools and newer construction. The west and south sides offer more affordable options with different demand dynamics. The Marion County Small Claims Courts handle a high volume of landlord-tenant cases, and the Indianapolis market has seen growing attention to housing affordability issues. While the state preemption statute prevents local rent control, Indianapolis has implemented programs aimed at connecting tenants with resources and addressing displacement. Landlords in Indianapolis should stay informed about local housing policy developments. Fort Wayne, Indiana's second-largest city, has a growing and diversifying economy driven by healthcare, manufacturing, including the defense industry, and a revitalizing downtown. The rental market is more affordable than Indianapolis and offers moderate pricing power. Fort Wayne has seen investment in its downtown and riverfront areas, which has improved demand for urban rental housing. Evansville, in southwestern Indiana, has a stable rental market driven by healthcare, manufacturing, and the University of Southern Indiana. The market is affordable and moderate, with pricing power that varies by neighborhood. South Bend, home to the University of Notre Dame, has a rental market influenced by the university, healthcare, including Beacon Health System, and a growing technology sector. The Notre Dame area commands premium rents, while the broader South Bend market is more affordable. The city has experienced economic revitalization in recent years, which has improved rental demand in certain neighborhoods. Bloomington, home to Indiana University, has one of the tightest rental markets in the state. IU's large enrollment creates intense demand for housing near campus, and rents in the student market are high relative to the city's size. Rent adjustments in the student market typically occur at the beginning of each academic year. Bloomington's progressive political culture and active tenant advocacy community mean that landlords should be particularly attentive to compliance with local anti-discrimination protections, including the source of income provision. West Lafayette, home to Purdue University, has a similar student-driven dynamic. Purdue's large enrollment and the university's growing research enterprise create strong and consistent demand. The rental market near campus is competitive, and rent adjustments follow the academic calendar. Muncie, home to Ball State University, and Terre Haute, home to Indiana State University, have student-influenced markets on a smaller scale. These communities are more affordable, and pricing power is more limited than in Bloomington or West Lafayette. Military-adjacent communities have rental demand influenced by military housing dynamics. The Naval Surface Warfare Center at Crane in southern Indiana, Camp Atterbury near Edinburgh, and Grissom Air Reserve Base near Kokomo each generate some military rental demand. While Indiana's military presence is smaller than in some states, landlords near these installations benefit from understanding BAH rates and the military housing market. One best practice for Indiana landlords: build rent increase provisions into your leases from the beginning. A clear lease provision that specifies how rent will be adjusted at renewal, whether by a fixed percentage, a CPI-based formula, or a market rate adjustment with a specified notice period, sets expectations from the start and eliminates the surprise factor that can lead to tenant departures. Indiana courts enforce lease terms as written, so a well-drafted provision gives both parties certainty. Another best practice, for landlords in university towns, understand the competitive dynamics of the student housing market. Purpose-built student apartments with modern amenities, proximity to campus, and all-inclusive pricing have become increasingly competitive in Bloomington, West Lafayette, and other college communities. If your properties compete in the student market, your pricing must reflect what students are willing and able to pay relative to these alternatives. Overpricing leads to vacancies that are especially costly in the student market because of the fixed academic calendar. For landlords who own properties in multiple Indiana cities, verify the local anti-discrimination ordinances in each jurisdiction. Indianapolis, Bloomington, and other cities have enacted protections beyond state law, and a rent increase that's legally unremarkable in one city could create discrimination exposure in another if it appears to target tenants in a locally protected category. Indiana's manufacturing economy creates rental demand in communities with major employers. Cities like Columbus, home to Cummins Engine, Elkhart, the center of the RV manufacturing industry, and Lafayette, home to Subaru of Indiana Automotive, have rental markets tied to industrial employment. When these employers are hiring and expanding, rental demand increases. During downturns or restructuring, demand may soften. Landlords in manufacturing-dependent communities should monitor the health of the local industrial base when planning rent increases. Indiana also has specific requirements for manufactured home community lot rents under the Manufactured Home Community Landlord-Tenant Relations Statute. Landlords who own or manage manufactured home parks must follow specific notice and procedural requirements for lot rent increases that differ from standard residential tenancies. For Indiana landlords who participate in the Housing Choice Voucher Program, rent increases must be approved by the local housing authority. The authority evaluates whether the proposed rent is reasonable by comparing it to comparable unassisted units. In Bloomington and other jurisdictions with source of income protections, the interaction between voucher program rules and local anti-discrimination law adds an important compliance layer. Submit increase requests well in advance. Indiana requires landlords to return the security deposit within 45 days of the tenant vacating. Indiana does not have a statutory cap on the amount of the security deposit, though market conditions effectively limit what landlords can charge. While these rules don't directly regulate rent increases, landlords should understand that increasing rent doesn't automatically entitle them to collect additional deposit from an existing tenant without a new agreement. For the complete guide to Indiana rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our landlord-tenant law series.